Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are talking about an application made pursuant to Section 86A of the Trustee Act in relation to the administration of a trust. Now, before that sends you to sleep, I'm going to put in place a few background facts and we're going to hold hands together and we're going to get through it, believe me. So, what we have is a reasonably successful kind of senior family member who, through the 20th century, sort of sets up a green grocery business, enjoys some success, acquires some real property, acquires some publicly traded shares, and puts them into this trust structure. Now, this person is a number of things pursuant to the terms of the trust. This person is in control of the trustee, and as you and I know, the trustee is the person who legally owns the assets of the trust, and they legally own the assets for the benefit of the beneficiaries. This person is also a beneficiary of the trust. Crucially and importantly, this person is also an appointor of the trust. And the appointor role is sometimes thought of as the person who can hire and fire or appoint and remove the trustee of the trust. So we're going to get into the way this trust operated and the nature of the litigation in a moment. But what I'd like you to have clearly in mind is that we have this influential person who's in the position of appointor as well as some other relevant positions as well. Now, sadly, this person passes away in 2011, the trust having been settled in 1986. So there's this period of, about 25 years where the trust is chugging along while this person is alive, and then after this person's death, there's a sort of a 15-year period leading up to this piece of litigation. Now, the reason the piece of litigation arises is that it's an application brought by the trustee pursuant to 86A of the Trustee Act here in New South Wales to deal with some sort of interesting wrinkles in relation to the nature of the trust. There are some challenges. The word glitches appears in the judgment in relation to these issues, in relation to how the trust works. The short version is that the trust deed itself does not account for a new appointor to be appointed. Do you remember how influential person was the appointor? When they died, there was no more appointor, and the trust deed doesn't allow a mechanism for a new appointor to be put in place to come and take the place of the now passed away appointor. So we've got no appointor. And secondly, there are a number of classes of beneficiaries, and one of the classes of beneficiaries falls away and is no longer eligible to receive benefits from the trust if the appointor has died. Now, crucially, these sort of appointor being alive provisions are not supported by any reasoning. We don't really understand why our influential person caused the trust deed to be set up in this way. And there's actually some evidence before the court of a relevant accountant at the time who says that it appears to them that the terms of the trust were essentially just part of a standard precedent that someone might have employed at the time. And so the provenance of these slightly strange sort of appointor heavy with no appointor replacement provisions come from nowhere. The court gives the matter an extensive amount of consideration with great respect, and consideration is given to the nature of the role of the appointor, and a number of things fall from that. Now, the appointor is not a magic word that has a meaning in and of itself. It is a word or a role that has a meaning based on the specific trust deed. So dependent on the terms of each relevant trust, of each relevant deed, they are the terms that are going to dictate what that specific appointor is able to do. Now, there's another important point, that the role of appointor is not a fiduciary role. It's not a role that requires the appointor to put the interests of others ahead of themselves, unlike the role of, for example, a trustee. And so there's scope to take a look at the way the appointor's role is executed. The court then looks at the nature of these kind of beneficiaries, the beneficiaries who will continue to benefit after the appointor's death, and also the class of beneficiaries that fall away, that no longer enjoy a benefit after the appointor's death, and sort of reflects on the challenge of this. The court then turns its mind to what power does it have to put in place appointors, and finds that pursuant to its inherent jurisdiction, the court has the power in and of itself to appoint appointors, the court considers that pursuant to 86A, the history and nature of which the court spends some time reviewing, it has the power to approve different amendments to trusts as well. And so what the court finds, essentially, is that it's going to use its inherent power to put in place the new appointors that the plaintiff, that's the trustee today, the plaintiff, is seeking to appoint. It's going to use its powers to re-broaden out the class of beneficiaries back to before the influential person's death. And there's another question that a plaintiff raises to say, hey, can you give us a new power to appoint new appointors in future? And the court says, well, no, we're not going to do that at the moment, but there could be scope for you to bring an application like that in future. So what we have is we have this trust deed with these strange powers that are unexplained. We have the trustee, who is the plaintiff, come in today to try to sort them out. And we have the court, with great respect, taking a reasonably practical approach to solving the issues that are afflicting this trust. I hope that discussion assisted you, and I look forward to chatting again soon over another coffee and in respect of another case note. Cheers.